Hi, warriors. This is Jalen, my legal warrior. And today's segment is going to be about child custody when you are a military spouse or parent. If you are a military spouse or parent, there are special family code sections that do apply to you that would not ordinarily apply to other parents. So there are protections in place, especially for those that are subject to deployment. So let's take a look at Family Code section 3047. So a party's absence, relocation, or failure to comply with a custody and visitation order is not by itself going to justify a modification or custody or visitation order if the reason for the absence, relocation, or failure to comply is the party's activation to military duty or temporary duty, mobilization in support of combat, or other military operation or other military deployment out of state. So if a party is with sole or joint physical custody or visitation and they receive a temporary duty, deployment, or mobilization orders from the military that requires them to move a substantial distance from the party's residence or otherwise has a material effect on the ability to exercise custody or visitation rights, then any necessary modification of the existing custody order shall be deemed a temporary custody order made without prejudice, which shall be subject to review and reconsideration upon the return of the party from the military deployment, mobilization, or temporary duty. Let's take a moment to explain why these two sections or these two subsections are important. Because the purpose is the court doesn't want a military spouse to keep going back and forth within the court system to make modifications for child custody and visitation, especially when we're not entirely sure how long the deployment might be. And they're only supposed to be temporary orders without prejudice, meaning they're not going to be held in a negative light because they are being deployed or have to move due to their military duties. And so the court, again, does not want the parents back and forth over this particular issue. Because let's say a parent does have 50-50 custody, for example, they have joint physical and their visitations are equal. One parent deploys and then they're gone for, let's say, a couple of years. And when they do come back, they still have the ability to exercise joint custody. They are still able to see the children every single week. And in fact, the children still have that bond with their child, which would allow them to continue that sort of visitation and that relationship. And the way to maintain something like that is to be in constant contact with the children while they're deployed, if that's at all possible. So having a relationship with a child, to me, isn't just limited to just the physical aspect of it. You can build a bond and attachment with your children, even if you are overseas, even if you are deployed, to the best of your ability. And it would also be very helpful if the other parent is cooperative in maintaining that relationship. So let's move on. Section 2. If the temporary order is reviewed upon return of the party from the military deployment, mobilization, or temporary duty, there shall be a presumption that the custody order shall revert to the order that was in place before the modification, unless the court deems it's not in the best interest of the children. And just a quick example of that is if a parent is diagnosed with PTSD and their behavior is negatively impacting the children, their demeanor is negatively impacting the children, and therefore the custody arrangement that they had prior to their deployment or military orders is no longer in the best interest of the children. We need to make sure that this military official does get the help that they deserve in order for them to go back to their visitation schedule with the children. So it has to be child-centered. So keep that in mind. The best interest of the children is all about the children. This does not mean that the court cannot order a 7:30 child custody evaluation or child custody evaluation through section 30111. Unless the party opposing this reversion back to the order before they were deployed, they have to make a showing on its face that the reversion is not in the best interest of the child. So if you do not believe that the other parent is able to exercise the visitation in the same way that they did before deploying, then you have to show the court why and request a child custody and visitation evaluator under 30111 or 730. So if the court does make a temporary order, it shall consider any appropriate orders to ensure that the relocating party can maintain frequent and continuing contact with the child by means that are reasonably available. So phone, email, virtual contact, those are ways to continue the frequent contact between a deployed parent and the child. So upon a motion by the relocating party, the court may grant reasonable visitations to a step-parent, a grandparent, or another family member if the court does all of the following. Of course, this applies if both parents are getting deployed and they're not going to be available to care for their children in their home state, and so they need to leave them with a relative or some other guardian. So the court has to find that there is a pre-existing relationship between that family member and the child that has engendered a bond, and the child that has engendered a bond such that visitation is in the best interest of the child. The court has to find that the visitation will facilitate the child contact with the relocating party. Balance the interest of the child in having a visitation with the family member against the right of the parents to exercise parental authority. Now, this last section could apply. Now, it is possible that a military parent is the primary custodial parent, and that having the non-custodial parent who might just be on supervised visitations or has such minimal contact, like there's no overnights with that parent, that it doesn't make sense for the child to be in the full-time care of the non-primary parent, and therefore that should be with the step husband or step wife or their grandparents, because there's that pre-existing relationship, and it's in the best interest of the children to have that and maintain that, instead of having the other parent essentially have sole custody of the child while the military spouse is deployed or the military parent is deployed. So keep that in mind. But the best usage of this is, of course, if both parents are deployed and they essentially have or share joint physical and legal custody. Now, this paragraph doesn't increase the authority of the persons described in subparagraph B, so the step-parent or the grandparents. The granting of visitation rights to a non-parent shall not impact the calculation of child support. And if a party's deployment, mobilization, or temporary duty will have a material effect on the party's anticipated ability to appear in person for a regularly scheduled hearing, the court shall do one of the following: expedite a hearing date to determine custody and visitation issues prior to the departure of the party, or allow the party to present testimony, evidence, and participate in court-ordered child custody mediation by electronic means, which could be telephone, video conferencing, or some way on the internet, to the extent that the technology is reasonably available to the court and protects the due process rights of all parties. So what does that particularly mean? Means if somebody's going to get deployed in a few months and the other parent is essentially the non-custodial parent, and the deploying party doesn't want the other parent to have sole physical custody of the children and would think it's in the best interest of the children that someone else takes over the parenting or the timeshare of the military parent, then you would need a hearing, and that hearing needs to happen soon, needs to be expedited. So there's two ways that the court can fashion those expedited orders. A relocation by a non-deployed parent during a period of deployed parent's absence while a temporary modification order for a parenting plan is in effect shall not by itself terminate the exclusive and continuing jurisdiction of the court for purposes of later determining custody or parenting time under this chapter. When a court of the state has issued a custody or visitation order, the absence of a child from the state during deployment shall be considered a temporary absence for purposes of the Uniform Child Custody Jurisdiction Enforcement Act, and the court shall retain exclusive continuing jurisdiction under Family Code Section 3422. So what these two sections, again, allude to is if the military spouse or military parent and the other parent don't reside in the same county or the same state. And so the court found it would be in the best interest of the children, or the parents decided together that the children would go live outside of California with the other parent. And so if that is the case, it doesn't necessarily mean that now the other parent that is exercising sole legal and sole physical custody of their children, that they can run down to the courthouse and now open a brand new proceeding in their home state, because the home state of the children has already been established in their current proceedings, and it's supposed to be California, and it's only due to the fact that the parent is being deployed, and that's why they're going to the other parent in a different state or county. So that's very important to also note. So the deployment of a parent shall not be used as a basis to assert inconvenience forum. For the purpose of this section, the following terms have the following meanings. So deployment is a temporary transfer of a member of the armed forces in active duty status in support of combat or some other military operation. Mobilization means a transfer of a member of the National Guard or military reserve to extend active duty status, but does not include National Guard or military reserve annual training. Temporary duty means the transfer of a service member from one military base to a different location, usually another base, for a limited period of time to accomplish training or to assist in the performance of a non-combat mission. It's the intent of this legislator that this section provides a fair, efficient, and expeditious process to resolve custody and visitation issues. When a party receiving temporary duty, deployment, or mobilization orders from the military, as well as at the time that the party returns from service and files a motion to revert back to the custody order in place before the deployment. The legislator intends that the family courts shall, to the extent feasible within existing resources and court practices, prioritize the calendaring of these cases, avoid unnecessary delay or continuances, and ensure that the parties who serve in the military are not penalized for their service by a delay in appropriate access to their children. This is a very important family code section for individuals that are in the military. It would essentially allow for the parents, especially during COVID-19, if you're concerned with the court's closure, that you are not going to be able to be exercising any form of visitation. When you come back, you have to start this process all over again. Well, you don't. The other party does have the burden to show that the old schedule is not in the best interest of the children, and you would have to go through that process and defend why you should not have the schedule that you currently have or the schedule that you had before going on deployment. All right, thank you, warriors, for sharing this video, subscribing to our channel. Please make sure that you do share this video, warriors, with friends, family, colleagues, coworkers that might benefit from learning about military child custody issues. Thank you in advance, warriors, and please share our content. We greatly appreciate you and our viewership, and we hope that you are staying safe during COVID-19. Thank you.